Hello, welcome to the COVID updates for employers and foreign workers. I'm going to give it a few seconds to have people join. I hope you all have had a safe weekend, and I know that there's a lot of things that have been going on that are disconcerting, and we hope to address some of those today. So one of the first things I want to talk to you about is what I call, another brick in Trump's wall. What's happening is that there are so many changes that are happening behind the scenes. Things that have not taken fruition, but we hear about through, newspaper publications and other medium where people are turning the rumors, but there is a lot going on behind the scenes. While no one's really focusing on immigration, everyone else, there's so many other big issues that people are, kind of discussing. It's important to kind of put all of that in perspective. So that's what we hope to do today. But first, let us talk about what happened last week. So last week we talked about the status versus stay, different rules for different statuses, and truly all the issues that relate to changing status, extending status. When do you have work authorization? What's the difference between lawful status and a status authorized by the Secretary of Department of Homeland Security? What is the difference between the two? What happens if, you file for a change of status to one status, and then you also then file another change of status, like for an F1 or a B1, or you're planning to go to school and you're changing from a B2 to an F1, but because it takes so long, that your B2 is going to expire. What are the rules regarding that? So if you didn't get a chance, that's what we spoke about last week. And today we're going to talk about some of the other issues that are, bubbling about. The issues with the fact that there's a funding issue with the USCIS and how that can impact you with the already delayed processing times. Things regarding the article that came out in Roll Call about the ceasing of immigrant petitions and why the focus is on naturalizations. And then finally, what are the additional restrictions that they're going to put, if any, on H's and L's and perhaps OPT? And we discussed last week, I think it was the week before, on what exactly the authority is between the president and the USCIS. But we're going to delve into that now, and some other things that have been coming up, that we've been aware of through, our clients or other people reaching out to us, that we wanted to at least let you know were issues so you could address them, if need be. So, like I said, last week we talked about the implications of a status change and what is lawful status versus unlawful. If you didn't catch it, you can always, check out our YouTube channel, and as a result, kind of catch up on some of the things that you want to learn about with those issues. Those are really important, and they're complex issues. So even if you heard the the webinar last week, it may not be a bad idea to go back and do a refresher, because it's, the maintaining status is your responsibility. And so not knowing is never a defense. And so it's really important that throughout this, you make sure that your status is up to date, you know what the rules and regulations are as you're navigating this. Because you don't want to rely on anyone else for the resources. You want to make sure that you're equipped with the tools to ensure that your long-term immigration goals are not impacted by some short-term decisions you may make. So go ahead and take a look at that. So first, we're going to start off talking about reduced immigration filings. Funding. I meant funding, and which are causing financial shortfalls for the USCIS. So it is, just so you know, the USCIS is an agency that's highly self-funded. And for any of you that have been filing any type of immigration for any type of immigration benefit, you know that it's not cheap. They're expensive filings. And in fact, for an H-1B, if you're a company that has over 25 employees, there is the filing fee, which is $400 and something, and there's the employer fee, which is either $1,500 if you've got more than 25 employees, or $750. There's a $500 fraud fee, and then there's the premium processing fee. But because of the current policies, there's been a vast reduction in immigration filings. And as a result, the agency has found itself in a funding shortfall. They're asking Congress not only for additional funds, but the ability to increase fees, filing fees, in addition to the increases that they undertook last year, which, somehow, you can almost say that it is restrictive to, those people who may not be able to afford that, those expenses for an immigration benefit. So let's take a look at what some of the filing issues are. I'm sharing again. So there we go. So as I said, the reduced immigration filing. So how does that impact your process? Well, the USCIS has a shortfall of $1.2 million. And this week, they're supposed to furlough 15,000 workers for 30 days. It's a reduction in workforce for 3/4 of its workforce for the next month, absent congressional intervention. So, the problem is, for all of you that understand what the immigration processing has been since this administration, there's been incredible processing delays. I mean, record levels. And because of COVID, there's been, the application centers were closed, USCIS offices where you had interviews were closed, and there was a substantial slowdown in processing. So it was already a very big or delayed, long processing time. Now, after COVID, it's of course going to be further delayed. But if they decrease their workforce by 3/4, I can assure you that it will impact processing tremendously. Yes, the good news is there is premium processing that is, being reinstated in phases, but, unfortunately, that doesn't apply to all types of applications. So for example, if you're changing your status from an F1, from a B2 to an F1, I-539 applications are not permitted to be filed under premium. So you don't get that premium benefit. And so that, those are the types of applications that may be impacted. I'm going to pause for a second to take some questions. I think we have. My current visa is on an H4 and I would like to apply for an F1. Me and my husband are legally separated from July 1st, 2019, and now my visa is expiring on July 15th. My lawyer is requesting for an extension, not sure what will happen. If I get the extension, I may only get it till October, November, right? So on an H4, it is a dependent status. So your status is dependent on your spouse's H-1B. Separation is not divorce, but once you're divorced, then you're no longer eligible for an H-4. So it does make sense that you go ahead and file for a change of status to an F-1 to ensure that you're maintaining status and you're not dependent on your H-4. If there are special issues related to your separation, there may be other mechanisms that you could leverage. So if you want to email me at info@cellolaw.com so we can talk a little more privately about this, there may be other things that you can do. So I'm sorry to hear about all the things that you're going through. It's hard enough dealing with a personal issue. On top of that, you got to worry about your immigration. But there are, like I said, a couple of different mechanisms, assuming that your separation is, that there are reasons for the separation fall under the certain benefits that you may be eligible for. So because of the, the personal discussion that's going to require, email me at info@channelraw.com and we can talk a little bit about it and see if you're eligible. Wow, lots of questions came up. Okay. I'm going to apply for an F1. I'm going to apply for an F1, and I want to know the legal procedure. So till my visa gets approved, am I eligible to stay in the United States? Yes, you are. What you would do is, let's say you're applying for fall. You file for an I-539. Now, here's the issue. It's going to take longer for the I-539 to get approved. So what I would do is file both for the extension and then file for the change of status. So if you file for the extension, because your status, I think you said, is expiring, your visa is expiring, but how long is your husband's I-94 valid for? So it's not your visa that dictates your stay. It is your I-94. So if your I-94 is going to expire in less than 6 months, you can go ahead and file for an extension for that and then file for a F1 visa. You have to file these things, and we covered this in last week's YouTube. So if you didn't listen to it, I would go back and take a listen, because one of the critical things is if you're going to file for any type of change of status or extension, you have to do it within the period that your I-94 is valid. Again, send me an email and we can talk through some of this, but I would take a listen to that YouTube video on status changes, because it directly impacts some of the issues that you're worried about. Another question: when will the visa stamping offices, when they will open in India? We don't know. The cases in India, they saw a slump and now they seem to be on the rise. So I think, I don't think it's going to be any time soon. But if you don't have a visa, if you've got friends that are overseas on an H or an H4 and L, I would advise them, if they've got a visa, to come into the United States. Now, they are taking some emergency requests for visa processing. So if your company can demonstrate that it's emergent, that you come back to the US, you may be able to get an emergency visa to re-enter. So that may help. Yes, Chandrapurta, I understand you've got a few more questions. Like I said, because of the very personal issue that's evolved with your questions, send me an email at info and we'll set up a time to talk where we can talk one-on-one and it's not in a public setting. I'm happy to help you with your figuring out how to transition through your divorce and all the other issues you're going through. So please do that and we'll set up a time. I won't charge you. I will do that pro bono just so I can help you out with your concerns. Another question. I'm on an H4 and my H1B was picked up in this year's lottery. The petition got approved in 20 days without premium, along with a change of status. This does not look like a reflection of USCIS delays and processing times. So my question is, what changed? Is it an effect of the new application process? I just think sometimes people get lucky. It may be the adjudicator didn't have a major backlog. Maybe the files got mixed up and yours got put on top. I mean, there could be a number of things. But the key is, as long as you've got an approval with an I-94 attached, it's a valid approval. So I wouldn't worry about the fact that you were one of the lucky ones that got approved very quickly. He was charged with DVP in November. Yes, Chandra, like I said, let's talk, because I have a lot of questions. It's not something simple that I can answer on a Q&A, but talk to me and then we'll set up a time to discuss this together. Hi, Lakshmi, thanks for conducting this. Maybe I missed the conversation. Is the executive order sure will come for H-1B OPT by end month end? I'm going to be discussing that in upcoming. I've already got a master's from Chandra Porter. I already got a master's for this summer already. Good. And the one thing is, you can start school on an H4. There's nothing precluding you from starting school, but I would go ahead and file for, like I said, the extension as well as the change of status. I finished my EB1 final interview process almost a year back. My priority date is July 2017. Any speculations on GC issuance on currently available quota? Yes, I'll be talking about that in just a second. When the process for green cards will resume, including interviews, that's next up on the agenda. Please, can you tell us the email? It was hard to understand. Here, let me write it in. The email is info@challa.com. So here is the email, info@challalaw.com. Oh, thank you. Is it blurry? Let me see. Thank you for telling me that. I don't know. I was looking at that too. It's looking fuzzy, right? I don't know what the issue is, but I know I look like I'm in some sort of dream sequence because it's so blurry. I apologize, but I can't figure out, what the problem is. I tried changing angles, but I still seem to be a little blurry. So after this is over, I'm scared if I touch the lens now, I may do something to screw up the PowerPoint. So, but I will do that. Until then, think of me in a dream sequel, where I'm talking to you about happy immigration outcomes down the road. So I know that there's more questions on the Q&A. Let's go to the next slide and I will stop again so we can discuss. All right. So funding matters. Funding matters because you have the USCIS offices opening up June 4th with record backlogs. There's a national, there's a class action lawsuit for naturalization applicants talking about the major delays. And there is a rumor, BuzzFeed and Roll Call had some sources from within the administration that said that they're going to halt immigrant interviews so they can focus on naturalization. So let's talk about those things just a little bit. So I don't think that there is going to be any expedited processing for naturalization applications. They are going to be slow. And the reason is this is an election year. And there is the assumption that immigrants, when they are naturalized and are eligible to vote, that they vote Democrat. So it's unfortunate that that's part of, the equation, but that's what's going to happen. Now, even though they're saying that they are going to be focusing on naturalization applications, and this is all assuming that BuzzFeed's, BuzzFeed and roll call, what they're saying is correct. But if that is the case, then, and it may be, that they will halt immigrant petition applications for a while. Now, I'm going to be tweeting about it. I'm going to be fighting it. I'm even planning to tweet to the president to say, this doesn't make any sense. That a lot of these individuals have been waiting 12 years in the process. They've got children that may age out. And they're already, in order, especially for employment-based, they are already in a job. They have to work same or similar employment in order for the permanent resident, adjustment to be approved. So the idea that this will somehow help the high unemployment rate is absurd. So we think, we're not sure, and that's why it's important, if you haven't subscribed to our, immigration updates, and if you don't follow us on social media, please do that, because we try to get that information out as soon as we possibly can. So, but keep in mind, these are things that, from a strategy perspective, you've got to keep your eye on, because even though they haven't been implemented, what's next? What is it that we can do? So hopefully Congress will act and give, the USCIS the funding that they need, so 15,000 people don't have to be furloughed. And I think if we see that, they have no justification to say that they will prioritize certain types of filings. Now, I'm also reaching out to a number of our congressional members to let them know what the impact of the funding is and how serious it is. So along with just our processing, we try to do as much advocacy as we can, supporting the voice of our clients and many people who are going through this process. So let me see, I think they're, okay, yes. Well, maybe after the phone call, Chandrakorta wanted to know when I would respond. I certainly can't respond now, but I pretty much will respond greater. Okay, somebody was saying volume. Can you hear me now? Is the volume better? Let me know if you can hear me better now that I've adjusted the volume. Can you guys hear me now? Okay, good, good, good. That's excellent. So now let's go back to our slide. Okay, so this is the funding issues that we've been seeing. So keep, like I said, keep posted on all our media outlets, whether it's on Twitter or subscribe to our newsletter, because as soon as something comes out, whether it's the weekend, late at night, even if my staff is not there, I send it out on blast, just so, hey, this is coming up, watch out. So make sure you subscribe. There's gonna be a button at the end of the PowerPoint. And so it's uploaded, you can get that, or email me at info@cellolaw.com and we'll send you information so we can get connected, and we can make sure you're getting the information you need. Okay, so some of the things that we've been hearing, and I just want to kind of highlight some of that, is the CARES Act, interestingly enough, did not really distinguish from individuals that are here on some type of immigration status and those who are not. So for companies that are eligible for some of the CARE relief, The only thing that they needed to do was to make sure that they had a US-based entity and they were eligible for care relief. Now, a certain amount of the CARES money was dispersed to universities. And so universities are, in addition to ways they can use that money, they were also, handing that out as grant money to their students, who are, some of whom can't travel back home now, and are facing a lot of challenges through not knowing what's going on. I mean, today, interestingly enough, I was just looking at the latest FAQ last week by SEVP, which kind of is an agency within the Department of Homeland Security that, your SEVIS, the schools and universities, and they added a new section called Developing Issues, and they stated it was a fall semester. They still didn't know what they were going to do for the fall semester, but it is under consideration. And as soon as they have finalized what rules they have for fall, they will update it. So we found that to be really interesting. So what Betsy Duval, who is the Secretary of Education, did was she sent an emergency directive to the university saying certain types of students are not eligible for the CARES Act. Now, even though Congress didn't put that restriction for the funding, she cited Title IV, which universities have to adhere to, in saying that those who are undocumented, DACA beneficiaries, and foreign international students are not eligible for any care relief through the university. I have a sinking feeling that that's going to be challenged. Usually, an agency can't impose a requirement that is set by Congress. And this is different than federal subsidized loans and grants, which are subject to the Title IV. This is a disaster relief. So I don't know how that will interplay, but I am looking into it. And that was one of the, silent issues that came out last week. Another thing a lot of people are struggling with is the new employment authorization form. The form that's online is it's from December of 2019, and a new form has been issued, and a lot of people are worried that, can I file with the new form? I mean, the old form, is there going to be a problem? Well, the Federal Register initially had a notice about the new I-765 form on January 16th, 2020. On April 20, providing the 60-day notice, on April 22nd, they extended the notice and comment period until May 22nd, then providing another 30 days. So they have said in the federal notices that you can use the old form until the new form has been published after the notice and comment period is over. So we wanted to let everyone know that, because we've received a lot of questions on whether they can file with the old form. Lastly, there is an issue on, very interestingly, called DHS trips. And several individuals who were overseas, when they were getting ready to travel and they printed their boarding pass to come back to the United States, it would say DHS trips, which means you have to go through a particular process. So the hold comes from the airline. I don't have any idea why they're instituting this, but it is important that it is something that has been happening regularly. And there is a procedure to go through. You should be able to resolve it fairly quickly, but we'll be publishing that in our news update. So, you're equipped with dealing with that when that comes up. So let me take this opportunity before we move forward to answer a couple of questions that have come up on the Q&A. I am a postdoctoral fellow in the past 3 years and got my PhD from the US. Primarily, I'm working in the cardiac field, and a smaller project on COVID-19. Is there any special quota for EB1 researchers working on coronavirus? Well, the one great thing is, even if there's a halt on immigrant processing for those people who for all immigrant petitions, there is an exception for healthcare workers that are directly working on COVID. And we were special counsel to the Attorney General for about a decade, until I was thinking about merging with a law firm, and I had to withdraw from representation. So if you'd like us to take a look at your resume and let you know whether we think that you'd qualified, we've filed tons of these and have been very successful with our EB1 applications. So I'd be happy to take a look at it. And there have been times where I've told people, please don't file, you're not ready yet, but here are the things you can do to ensure that your application gets approved. So I sent the email on our chat, info@cellolaw.com. So I'd be happy to look at your resume and take a look. And the good news is, even if it's restricted, it wouldn't impact you even if immigrant processing was restricted. And the other thing is, that's really something to highlight as an important initiative in the United States. So I think it'd be a great time for you to file your EB1 if you meet all the other criteria. How long is the wait for EB1 for Indians if I apply? Well, I think Oppenheimer, who deals with the Department of State, the backlogs and stuff, said in short time it's going to be current. So you could go ahead and file, and if you file now, that way when it becomes current, you can concurrently file your adjustment of status during that time. So that may be something you want to do. And EB1s, if you've got a strong enough application, you can file that premium processing. But there's some strategies related to that. So we may want to think about, once I look at your resume, I can tell you whether it's better to file premium or whether it's better to file, regular processing and upgrade to premium at a later date. But, the backlog should be addressed, and it should be current fairly soon. My wife was studying in the USA on a PhD. She came in November. We married January 2020. Then she got her study, and I was applying to dependent visa, but they are not giving on March 3rd. So when will I apply? So do I assume that you're outside the US? If you're outside the US, then I guess you're waiting for the consulate center to open. But if you were in the United States, USCIS is functioning, so you should be able to file for a change of status if you're filing for a change of status. But I would assume that you're probably overseas, and so you have to wait for the consulates to open up. Is it a right time to take admission for MS here in the US? I'm working on an H-1B. It would depend on why you want to take up the master's degree. Is there any issue with your continued employment? Is there a problem? Do you think you're going to get laid off or furloughed? If you just want to take a master's degree because you think it would enhance your current qualifications, then absolutely. And you can do that even while you're on an H-1B. You can do like some of the executive master's programs or an evening master's programs. But unless you think that your status is, that there's a problem with the status, you don't have to necessarily change your status to F1 to do that. I hope that helps. Okay, yes, RFE now related to STEM OPT, but my employer did not provide any training. How to respond to this concern paperwork? Has your employer at least been calling you every week? Is there any contact? Because that's what they signed off on. So they should be doing that. Any employer that is placing a STEM OPT at a third-party work site is required to demonstrate that they have oversight and that they are training the employee. The place where you are being placed, they're not supposed to provide the training. And so a lot of our clients, we advise them at the very beginning when they talk about their STEM OPTs, make sure you're making weekly calls, make sure you document those calls on a report or something. Are there emails back and forth between you and your employer asking about the progress and asking what's going on? So if you can show that either their phone calls or email correspondence or a combination of both, or some employers have a project management system where all their employees at third-party sites have to kind of give the employer updates. So if you have any of those things, those would be helpful to respond to that RFE. But you do have to demonstrate that that the employer is giving you some, oversight. Is it a right time to, okay, we answered that. I'm not sure if it was covered. Can you comment on any new rules regarding to L1A applications already submitted? Yeah, it would be I think if there's going to be any issues, and I'll talk about that in just a second, I don't think it's going to impact those that are already here seeking an extension. They can't do that for, a number of reasons. It's promissory estoppel is one of them. There's some very strong legal foundational issues that would not allow them to do that. So I don't think that will happen. So I think you're pretty safe with your L1. Can you process an L1A visa or E2 on premium now? Very shortly. I think the process for all applications is closer to the, I think, third week in June. So you can get the process started. Even if you file in regular, it takes some time to put together a good L1A or E2. And if you want some information on that, send us an email and I'll send you some charts and some information on L1 and E2 processing. I would do the E2 first and then maybe change to an L1 later. And there's some strategic benefits to doing that. But you can go ahead and file that now, and when the phase-in time frame for premium kicks in, you can upgrade it to premium processing at that time. But you want to make sure, anytime you're upgrading anything to premium, you want to make sure your application is strong. Because the whole idea of going through premium processing is for an expedited decision, and you don't want an RFE that could delay the decision and then not really give you what you want. How long does it take for a perm audit to get processed? It's filed in November. Audit was responded to in March 2019. Is there any way to expedite? There's no way to expedite perm audits. They can take anywhere from 4 to 6 months. But if you were worried about an extension, we've talked about this, we covered this previously, that if your perm has been pending for 1 year, including the audit time, you can get an extension beyond your 6 years, leveraging another part of AC21. So if that's what you're concerned about, that's one thing to look at, as you're assessing the time frame. Thanks for answering, but I do not have visas I want to pursue for a brighter future. Oh, wow. Well, Kieran, I would be happy to tell you what my thoughts are. There's a lot of, it depends on what your current background is, because you want to make sure your background is enhanced by whatever degree you're going to get. So email me so we can chat a little bit, and I'd be happy to give you my thoughts on, what are the areas that I'm seeing where there is growth and opportunity in the United States in terms of fields. So my sister filed April 10th for permanent residence status. Did your sister file, what year are they currently working on? If your sister filed for you for permanent residence, it's about a 15-year wait. So it's not going to happen anytime soon. So here is a good segue. Somebody asked about, any potential emails, and I'm going to halt questions just for a second so we can go to the next slide, and I'll come back, I promise. So the other, the impending, additional restrictions on H-1B, F1, F1 OPT, and L1s. They may, they can't really, because of a legal, foundational issue, issue called promissory estoppel. You can't give somebody something and then without notice a benefit or something, take it out from under them where it would, I won't say disenfranchise them, but where it could harm their business and harm them in, other ways. So, the fact that you've been given the H's and L's and F1 OPTs who are already here, it would be very hard to restrict those that are here already. They may, and besides, that's not within the president's executive power. He can only restrict entry. He can't restrict, issues relating to folks that are already here. They can impose additional requirements like they did when we were seeing the banking fiasco where all the banks had to be helped during that economic crisis. They put additional restrictions on what they had to do when they hired an H-1B. That they can do. But I think that if there is any executive order, it's going to be related to those who are going to enter the United States. And maybe restrictions on OPTs in the future that, that the employer has to show, maybe demonstrate that a higher standard for not simply hiring an OPT, but perhaps, have they tested the labor market? There could be other restrictions, but they can't do away with a program totally because of promissory estoppel. So I'm going to go back to the questions now. Let me see what. So like I was saying that to get the latest information, as you can see, there's a lot of things that are upcoming that I've been able to highlight, which is really important for you to know, because we have to know in order to have the best offense is a good defense. So you got to know what's coming up in the pipeline so you know how to navigate through the issues. But if you want to get the latest information, you've got to please subscribe. This button works. And, if you find some difficulty, with the button, or, if you look at, I had a button even on our last week's weekly webinar, you can go to that. And if that doesn't work, just email me at info@cellalaw.com and we'll make sure that you're getting the updates hot off the press as it's happening. Like I said, even on the weekends, late at night, I'm constantly keeping track of what's changing along with my team. So it's just not just me, but both of us are really, all of us are very focused on trying to make sure that we have the latest. But I believe there were a few more questions. Let me see. Great, Kevin. I look forward to your email. And I'm really excited about, the things that you can do. Education is critical for everyone. I'm a postgrad doctoral researcher. What do I need to do to start putting together a GC application? What is the timeline? Do you need to be on an H-1 to file? No, you don't. You don't need to be on an H-1 to file a permanent resident application. And there are some really specific things. If you email me at info@cellalaw.com, then I can, and send me your resume, I can take a look at it and tell you, whether you would have any problems with that or qualify. And I can also send you what the documents are, what the criteria is to be eligible for an EB-1. And like I said, I'm happy to make an assessment we've been doing, we were processing weekly, God knows how many EB1 applications. So I've seen them from all the universities across the nation, really, but substantially in the state of Virginia, because we were there. We were the Attorney General's, Immigration Special Counsel, and even under even under Ken Cuccinelli, who's acting director of USCIS. So, but don't blame me for anything that he's imposing. It's certainly not any of the things that we have advised. But send us that and we'll take a look at it. When do you think is a good time during the current plan to? Oh, I think as soon as you're eligible, I think it's okay to go ahead and get started on that and get that filed. Like I said, I think they can prioritize, immigrant visa interviews. They may be able to do that, but if Congress funds them, I don't think that they would be able to justify why they are restricting. Oops. So every, I'm sorry, I was trying to do something because I think there's email@chelawlaw.com. Okay, and I wanted to see if there were anybody within chat. Okay, one question, if you're still on status like an H4, and if it expires, while I apply for an F1 visa before it expires. Okay, so one thing about applying a change of status to an F1, you can only apply to a change of status to an F1 30 days prior to the expiration of your current status. So there's really statutory timelines for that. But if you file your H extension, right? You file your H extension. When you file your F1, you're on a stay authorized by the Attorney General because you've got an extension in progress. So I think that is, you've got to do both of those in quick succession. So if the reason why is F1s take a really long time to process. And you have to be in status, in A status, even if it's a status authorized by the Attorney General. So your I-539 is going to process as slow as your F1. So if you file those in quick succession, then when they go to adjudicate your F1, with that, you'll eventually let them know that you've got an extension pending, so that that won't be an issue with your F1 approved. Do you need to be on? No, we already addressed that. You don't need to be on an H1 to file a green card application. And I think I answered that, what to do. Off topic, can you choose to answer later? My perm was rejected and the attorney says it's a clear mistake. On behalf of the DOL. Well, Himanshu, you want to send me the denial? And if you have a copy of your, the actual perm application, if you can send those two things to me, I'll take a look at it and let you know whether, it was, a DOL mistake or whether it was something else. And there may be other things that they can do. Sometimes you can ask for a motion to reopen based on a clear DOL mistake, so you don't have to go through the long audit process. Do I work with I-530? Yes, we do process change of statuses, absolutely. So if you'd like us to help with that, we'd be happy to do that. Will you be covering the I-751 backlog at all? I just submitted I don't know how long it takes, backlogs and delays. I've submitted solid evidence, will an interview still will be required? Yes, an interview will still be required. And that's the whole problem with the application centers is they're saying that, once they resume, that they will resume processing, and all the people that were previously scheduled will take priority. So they'll schedule those first, and then any people that they need to schedule, they will schedule thereafter. If they furlough 15,000 USCIS employees, there's going to be a delay with the process. So the delay that you're seeing is a delay that is being seen across the board. And it's only going to get worse before it gets better. So, but I'm keeping an eye on whether Congress is going to fund USCIS. So if you haven't, like I said, subscribed to our newsletter, follow us on social media. Like I said, these buttons all work, so you just need to click. I'll be posting additional resources on YouTube, like remote employee, what is it required for an O1, which is very similar to what's required for an EB1. So I'm, kind of focusing on very specific topics. And, we use different forms of media to convey different types of information. So, make sure that, you sign up for those things. If you go on YouTube, our last week's seminar has the buttons that you can press. And if you can't, just email me and I'll be happy to send you an email with an easy way that you can link up to that. And do subscribe to our newsletter if you haven't already subscribed to it, because that really is the mechanism where you're going to get really detailed information and information about all our webinars and everything else that we're putting on, so that you can be abreast of the latest information. And I think there are 2 more questions. Let me see. If an H-1B transfer within 60 days, then what will be the status till it's approved or rejected? How much time I have to file a B2 after rejection? Okay, so if you're trying to file a transfer within 60 days, remember in a couple of weeks, premium processing is going to be applicable to all filings. So I would file it because while you're in that 60-day period, you're in an authorized status. And if you've got a job offer and if you're being placed at a third-party site and they have all the documents, there's no reason why your H-1B should be denied. So just make sure that it's being handled correctly. They've got to be really careful about the job titles they select, and make sure you have all the evidence needed to demonstrate that there is sufficiency of work. If you've got those 2 bases covered, the specialty occupation side, the employer-employee sufficiency of work side, your petition should not get denied. Now, the 60-day grace period, remember that is a discretionary grace period. That means the USCIS, when they're adjudicating it, have the ability to say, hey, we're going to allow you to use this, or we're not going to allow you to use this. I think if you can truly outline with great detail, the issues of COVID impacting you, especially, Lilith, right? So, you still can't travel back to India. I mean, very few people are allowed to go back. And I don't think that I think they're only taking folks that live in India as their permanent abode. And they're taking them on a lottery basis. So you don't even have, and that's a pretty big thing to highlight in your H-1B petition, is that you don't have the ability to travel back. So I think it should be good, but in prudence, you want to file and get an answer within that 60-day period, so then you can file for the B2. Because if it's outside the 60-day period, even though when you file for a transfer, you're in an authorized status, even if your status expires in between. After your status expires and you're no longer in an authorized status, you can't change to another status. So, that's some of the concerns I would have. Thank you. Will I still be able to travel while my application is being processed? I wouldn't travel now if I were you. First of all, if you're filing for a change of status, if you travel, you've abandoned your change of status. So you can't travel, whether you're filing a change or an extension, you shouldn't travel while anything's being processed. Secondly, like I said, the president has, tremendous power when it comes to entry into the United States. So any executive orders would most likely be reflected on restrictions about entering the US. So that's what I would be concerned about. Can I please get your email ID? Yes, I think we shared that screen. Let me put that back up. So if anybody wants to ask any, I don't know, it's, that's our webinar every week. And there it is, email at info@cellolaw.com. And I'll also type it in for people to see. info@cellolaw.com. There you go, 2 mechanisms by which you have it. So I think I have answered all those questions. What I'd like for you all to do, if you could, is I want to make sure that our sessions are helpful to you. If there are particular topics that you would like me to cover, I'd be happy to do that. So email me and let me know. Comment on our YouTube videos. I loved the fact that you told me that I'm looking a little fuzzy today, and so I'll try to take care of that next week. And if there's, like I said, anything else you want covered, because truly this is for you. This is to benefit you. And if you've got friends that are going through the same thing and they are looking for some direction, please share. Let's make sure that we're able to help as many people as we can reduce their anxiety about immigration while we go through this process. I have an H-1B valid until April 2021. I joined another company June 19, and their H-1 is valid till April 2022. I resigned company now. I want to go back to my previous company. Is there any legal complications with respect to the status as the previous company visa is still valid? Okay. So as long as the previous company didn't withdraw your H-1B, which most companies should because they've got ongoing wage obligations, you are typically eligible to go back. But in all, caution, if I were you, I'd file an amended petition to go back to my previous employer. And the reason is because although you're eligible to go back, that H-1 is still valid as long as it's not withdrawn or revoked. If there's an audit that's done, because not an audit, I'm sorry, a site visit that's done for your current application, you're not there. They have said, the whole reason why they've started requesting amended petitions is when you file with the DOL, or even at the minimum, send a letter in stating that you're going back to your old employer, but you want some document so that you can show that you've given them notice that it wasn't withdrawn, it wasn't, in any way revoked, to talk to your employer, make sure that's the case. And then since it's a valid, H-1B petition, you have the requisite I-9 documents to go back and work with that employer. But I would, like I said, minimum, try to make sure that, you do give them notice in some aspect, in some regard. So that is it for today. Oh, okay. Normally the visa bulletin is issued by the 15th of each month. So you can do that. If you have any additional questions, I've shown you my email. I sent it in chat and I sent it in the Q&A, info@cellolaw.com. Email us. Tell me if there's anything specific you want me to cover next week that could be helpful to you. Permanent residence processing, you know, any particular type of issue, remote workplace issues, OPT, training programs, we'd be happy to do that. Like I said, I'm here for you. I want to make sure that I'm a resource that you can depend on as we're going through these very, you know, stressful times. So let me know. Please share our information with your friends so we can reach more people and we can help other folks that are going through their stressful sessions as well. And again, let me see. I'm planning on getting it, converting my H1 to H4, and meanwhile, if I get a job, can I get it? Yeah, because you know, you can premium, by that time you'd be able to premium processing. The problem is when you change an H1 to an H4, it's an I-539. So there's no premium for that. So that's going to take forever. And so while the I-539 is processing and you're able to get new employment, you can file for an amended petition, you know, subsequently withdrawing your change of status, submitting your change of status receipt notice to show that you were in an authorized status when you filed. Why is it how long will it take from H1 to H4? A long time. I-539s are at the slowest peak. I think they're, what, 8-9 months at the minimum. So, and it may be, if there's furlough, it may be delayed even further. So, but it does put you in an authorized status. If you want to find out what the difference between a lawful status is and an authorized status, please take a look at our last week's webinar. It goes over those nuances really in detail, which is important for you to know. Oh, as long as you, that's why I wanted you to listen to the webinar. As long as you file within your 60-day period from an H1 to an H4, then while that change of status is pending, because you filed, you know, within the authorized status period, then you are in a stay authorized by the Attorney General. You're not in a lawful status, but you're in a stay authorized by the Attorney General. So you don't need to depart even if it's after your 60 days. Listen to that webinar. It'll clear things up. I am gonna sign off and see you back next week. Like I said, I know that you've got a lot more questions. You know, and I'd be happy to answer them. Email me, and if I haven't gotten to your question, send me an email. I will be spending the rest of the afternoon kind of looking at the info@Cellolaw questions that you've raised to try to give you some direction. Thanks again. Stay safe. Don't worry. We are, you know, really trying to be here for you during this time. And like I said, subscribe, comment on the YouTube videos. Tell me what you like, what you don't like, so I can, you know, better myself and make it better for you. And hopefully I won't be so fuzzy next week. Talk to you soon. See you next week. Until then, this is Lakshmi Chawla saying goodbye.